I want to go back to my line of questioning here. As yesterday, a CBC article reported that in a presentation to the Immigration Minister's Office, IRCC, the CBSA and unnamed U.S. partners were seeking the mass cancellation powers contained in Bill C-12 to cancel visa applications on a large scale and named 2 Pacific countries. Did your department give this presentation to the Minister's Office?
Thank you for the question. So we are looking for the basis of the presentation. We brief our minister's office regularly on a variety of issues. That being said, what I can say about mass cancellations and briefing the minister is that we have not proposed powers or legislation with a specific group of people or a situation in mind. The intent of this legislation is to ensure the necessary flexibility to respond to situations such as threats to national security, public health, the integrity of our immigration system, or other matters of public interest. But again, I do want to say that we are trying to seek the basis of the presentation in the department, but unequivocally can say that we have not proposed to our minister a situation with a specific set of individuals in mind.
Okay. Is your department planning on using mass cancellation powers in C-12 to mass cancel application from Pacific countries, or was the CBC reporting wrong report?
So yes, as I mentioned, we do not currently have any plans in mind. The legislation was not created with a group or a nationality or a set of circumstances. The legislation is drafted for use in exceptional circumstances, and currently there is no recommendation in front of the minister or no plans to be using this. The legislation has not yet passed.
Why did the minister tell the Citizenship and Immigration Committee that you weren't planning on using these mass cancellation powers on Pacific countries?
Absolutely factual. We do not have any current plans at the time or at the time of drafting of the legislation or the creation of the legislation with any country or type of document in mind.
Okay, so did you direct the minister to mislead the Citizenship or Immigration Committee?
I'm sorry, absolutely not. How so? How did she mislead the committee?
Because did you provide you with any advice for avoiding questions that are related to the questioning today?
I'm sorry, I don't understand the question. The minister, when she appeared at SIM, mentioned that the provisions were not created with any particular use in mind, exceptional circumstances, not tied to nationality or type of document, and I believe that that's what the minister answered. Okay.
Well, I would like to understand why should the Parliament grant you these powers without any oversight when you are unwilling to answer like basic questions that you should be able to clarify here today?
So the oversight mechanisms with the mass authorities piece rests with the Governor and Council. So the procedure would be is that in the event of an exceptional circumstance, a national security issue, mass fraud, even in the sense of not a cancellation, but a mass extension of applications, IRCC would write a proposal that would be consulted with the Department of Justice and other colleagues. It would go to the Governor and Council for review and further consultations and would result in a potential order in Council if the Governor and Council agreed. And this would include a transparent process through the Canada Gazette. So I believe that there are safeguards in place, and we're happy to answer questions around these provisions in the proposed legislation.
Okay. So by asking for these new powers, does the minister and IRC admit that they have allowed massive fraud and abuse of the immigration system to take place?
Absolutely not. This is not the purpose of the legislation. This is to strengthen the border and to complement other parts of the bill which allow law enforcement officials and other officials, as demonstrated in this panel, to protect Canadians' security and sovereignty.
Thank you, MP Gill, for these questions.